Okay, moving along. Our motto has been for 2020, together we're better, but actually I came up with another one for 2021, which is together we unite to build our real estate businesses. I should put out a poll and see if you like that, so I will later on. And click. As a member of Oregon Real Estate Investors Association, you're able to post your properties. Brad, is your property on our website? And I missed it?
I think so. I put it on a lot of places. After a while, I forget where I put it, but I think it's on there.
I get that, but I think it is. This is an old picture of it. So anyways, and all members receive a free website where you can post, find buyers, find sellers, and that kind of stuff. And we also, that picture is actually about free monthly education on from pros, real estate promo, and we'll tell you how to run your website better. Also, we have a Facebook group for members only, which is under Oregon REIA postings right there. And tune in, set yourself up so that you get alerts and see what's going on with your members of Oregon REIA. All right, so now I'm going to quickly do our haves and wants. I'm so excited to have all of you here today. If you, like Brad, we've already heard, has a property that he wants to sell, and or he has for you to buy, and you want some money.
Yes.
So I'm going to turn off the share for now, and let's go around the room and introduce yourself and tell us the name of your company and what you have or what you want. So I'll start with myself here because I'm such a diva. I have a need for more properties. I've got mine already sold that I'm flipping, so I'm in a need for more. So if you know some wholesalers that I don't know of, please let me know. And I am now going to go to Mike and Gail Glass. Please introduce yourselves.
You just did. We are Mike and Gail Glass, mother and son combination. We are GMG Solutions LLC. We finished up a house in December, and we also are looking for another property to work on.
Nice.
Go ahead.
It's occurred to me it might be nice if the next one was some sort of a house hacking situation, because I'm getting tired of living here. But other than that, we're open to pretty much anything.
So you two are among many others looking for a duplex to hack one side and rent out the other, it sounds like.
It could be anything.
Yeah, something like that. Stacy DeHart, you are to my right, so you are next.
Hello, Stacy DeHart with Icon Real Estate Group. And I am looking for a house in South Eugene that is a fixer that one of you guys would fix up for a buyer so that she can buy it for her family. I need a 4-bedroom, and I'm thinking around $425. I'm an optimist, can't deny. I also have a guy who wants rent portfolios. So if you know anybody who wants to get rid of their rent portfolio, he is down to look at that.
Great. Okay, I'm trying to talk. Thank you. Zach, you are to my, oh, wait, I'll come back to you during vendor. Okay. Pardon me. Dan Gandy.
Thank you, Grace. I'm Dan Gandy, Sharks Holdings, exit agent team. We are not looking for anything right now. We're really busy right now. So we're dealing with trying to close out some investment deals. And then I'm going to start buying properties out of state. So not interested in any flips. So that's where we're at right now.
Thank you, Jesse Lopez. Name of your company too, please.
Yes, Jesse Lopez with Home with Jesse, Icon Real Estate. We are looking for a duplex or fourplex or a flip property. I'm also have several buyers who are looking for a couple of acres in the 450 to 575 range. So if anybody has anything coming that's not already on the MLS, I'd love to see it.
So are you getting I hear myself echoing through somewhere. Jesse, are you getting any of the wholesaler postings on some of this land? But I think the ones I'm seeing are out of Portland area mostly.
Yeah, I've seen a lot of Portland property, but we're not really interested in going up that far.
Gotcha. And next we have Mike Grudzian.
Hey, I don't have a name of a company. I'm Mike Grudzian. I have some rentals. I got an Airbnb business. I do private money lending and haves and needs. I have just an interest in helping a fellow member, and I need your thoughts and prayers. Member joined us, our group, went about trying to do his first flip. He's got a construction background, but that's it. And he got in real deep with all kind of mistakes, and then on the day after Christmas got diagnosed with some serious medical conditions. So when this was brought to my attention by actually Zach, another fellow member, I just kind of took it under my arm and wings and said, I'm going to make this is going to be my pro bono effort to help this guy out. I'm going to see it to the end, whatever we can do to help this guy get through this process, get to the end of the process, get something out of the process. And I have to give kudos to Dan Gandy for helping and Grace for helping. It's, you know, I just feel for the guy. And so I made a commitment. I'm going to help him. Thank you.
Thank you, Mike.
Yes, thank
Grace.
you, Mike. You're making some headway there on that project. Thank you very much.
Thanks, Mike.
Wendy? Unmute.
Gotta unmute here. Well, I'm kind of your librarian. I just forwarded a list of Grace recently updated it, but the books are sitting in my garage, have been here. I don't know, right now I'm just looking to kind of engage with everybody, kind of just find out what's going on. I've been doing my Airbnb this last year. I'm still working part-time just for, give me something to do. But I haven't been invested in any properties. I'm talking to my son about maybe doing something in Dallas. And so, but it's just talk right now. Things have just been on hold for everybody, and it has been for me as well.
Right. Thank you, Wendy. So good to see you back. Okay, Brad Anderson.
I'm a real estate broker and I like to do flippers, but I sell all kinds of residential and commercial industrial real estate. Nothing is too big or too little. I'm always looking for a flipper for myself, but I've got a lot of investors that like to buy flippers. They all have money. Everybody has money, but nobody has property. Wonder why that is.
Interesting.
Yeah.
Thank you, Brad. Grady Lehman, introduce yourself to us.
Hello, I'm Grady. This is actually my first meeting, so thanks for having me. I own Elevated Investments, primarily only do buy and hold, so actually never sold anything. Anything from commercial properties to multifamilies and house hacks, stuff like that. Also, not really looking for anything right now. I got quite a few projects that I need to finish up. But I mean, a deal's a deal, and sometimes you got to do it.
Okay, thank you very much, Grady. Appreciate that. And Scott Stewart, Hoderless.
Good evening, everyone. Scott Stewart. Nope, not a real estate investor, but am here to support all of you. The name of my business is Odorless. I have an all-natural organic product that knocks out all kinds of nasty, unwanted odors. So in terms of how I can support you guys, if you have a flip property, if you have a rental, if you're dealing with feral cats in a crawl space and it smells to high hell, I can help with that. And no, you don't have to rip the whole building apart. But I can help you. I'll keep it odorless and we won't use any harsh chemicals during the process. Great to see all your smiling faces on here tonight.
Thank you. Make sure you put your URL or whatever you want to put in there in the chat, Scott. And I'm going to Jeanette.
Hey everybody, Jeanette Montague here. I am an investor, but I invest through Precision Capital, so I don't have to do any work because I'm lazy. I only work 100 hours a week at Farmers, because I'm an insurance agent. And my wants are, I need more specialty dwellings to insure. There isn't any inventory. So Farmers owns Foremost. Foremost is a leading insurer of specialty dwellings, and that includes vacant homes, tiny homes, manufactured homes. I also insure with outside carriers. I have a church, and I've managed to find a carrier for that. It's going to be a project, not a church group. It's just buying the building and flipping it. So I can insure for a project. So, and I need more projects. So give me a call.
Thank you, Jeanette. Appreciate you so much. Okay, Brad Larson.
We sold Game Farm Road for good profit, and we are, like most of you guys, looking to buy. So keeping our eyes peeled, trying to increase our marketing and doing some paid Google ads and a few other things. Hopefully we'll have some properties to wholesale here soon too.
Thank you. And did you want to mention your construction earning too?
Yeah, we're always open to helping you guys flip your properties. I've helped a couple of REIA members with their projects and doing the construction, remodeling, rehab.
Great, thank you. I see Brian Compton is on. Woohoo. Brian, unmute yourself and introduce yourself. We're on Haves and Wants.
Haves and Wants. Hi, I'm Brian Compton. And I don't make too many of these meetings, but I try to make them as soon as I can if I have time. So I just kind of popped in and out of here twice. So haven't heard what everyone's got to say. But I started getting into real estate here a few years ago and learning as I go. And I'm working on buy and hold properties is what my interests are. And just slowly growing without putting myself too far at risk, especially with this whole rent going on. So that's what I'm doing. And currently I have a duplex under contract. So that's my newest project.
Great, 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 great. So I think a lot of people are on here because of the discussion tonight that we're going to be hearing about protecting your assets. I've got Nancy Vandercook next.
Okay. Hi, Grace.
Hi.
Nancy Vandercook, live in Eugene, have 2 single-family rentals and no wants right now.
I like it, except for the vaccine. I want the vaccine.
Don't want that.
You don't want that either. No, get out of here. David Epstein, you're up.
Hi, I'm David. I normally purchase manufactured homes in parks, but seem to have expanded into purchasing complicated properties. Yeah, purchased one recently. I had to purchase it uninsured because I had no time to deal with the title company. and now I'm finding it difficult to get title insurance. So I'd love some advice by an attorney how to get title insurance when the title company, there's no reason for the title company not to give me insurance, but they're being very awkward about it.
And you will have a question later for our speaker, I know. Haston Taylor, welcome again.
Hello.
Hi.
I'm Hasten. I live in Corvallis, and I'm looking for either a duplex, which seems like everyone is looking for, or just a multifamily home of sorts, something I can house hack and get my mortgage covered. Yeah, that's my wants.
Great. Oh, okay. I am now ready for Aiden Fox. You want to say hello?
Hey Grace, sorry, I was doing the attendance. I'm Aiden. My haves and wants, I don't really have anything right now. I have knowledge of where I want to go, but I'm actually wanting to acquire a property to also house hack potentially with roommates and cover the mortgage, and pretty much just want to help any of you guys out in anything so I can gain experience and proceed with this career that I am fully invested in.
Thank you.
Yeah.
And are you checking people in for me by any chance?
Yeah, I just finished it up actually.
Great, thank you. Aiden is a volunteer that works for Oregon REIA and helps out with these meetings. And like, that's how awesome he is, wanting to get into real estate. Okay, I have Shalene Jordan left, and then Manuel.
Hi, I'm Shalene. So right now I'm starting to actually look out of state for properties just because you can go to the Midwest or somewhere and get it a little bit cheaper than you can here, and there's a little bit better cash flow out of state. So that's pretty much what I'm looking for. I'm not really looking for anything on the West Coast right now. I'm giving up.
Gotcha.
For a while.
And then we have the awesome Emmanuel.
Hey everyone, my name is Emmanuel Fergana. I currently live in Corvallis and I'm in my first year of real estate investing. I currently have a single family under contract. And so I guess what I'm looking for is any recommendations for contractors, handymans, and anybody, that's willing to give advice on, maybe managing rental properties. What I'm trying to do is a rent by the bedroom situation. But yeah, that's currently where I'm at with things.
Right. One of our members has, what, 2 or 3 bedrooms rented out, and then this and the other. Married. Okay, cool. Emmanuel, it works. All right, so I'm going to go back to my share screen. Did I get everybody here except for the speaker and Zach? Because that's who's next is Zach. And share screen. This is just so silly, but I'm doing it anyway. Here we go. Except for Virginia. Okay. Yeah. So hopefully you're seeing haves and wants right now. And then I'm going to click this. Aha! And we have vendor members, and we're so happy that Zach is here and sticks with us month after month, time after time, and will tell us all about Seton Funds and what Seton Funds does. Thank you, Zach. And I'm going to unshare so that we can see your cute face.
I didn't see your share that time, but it's
Oh,
okay.
you didn't?
No.
So we're still on? Oh, okay. Oh, I
Yeah,
see.
we're
Wait,
still on.
see? Now,
Oh,
there you go.
now-
There,
ah,
and
I see
now,
that.
there
Okay.
you go.
Good to see everybody. So Zach with Seton Funds. Seton Funds is a local private / hard money lender. We are family owned and operated, started by my mother, who's got 40+ years in the banking experience. She partnered with a commercial real estate developer to found our fund. We're growing very quickly. We didn't miss a beat during the COVID shutdowns. and we have all kinds of different loans going throughout Oregon. We lend mostly in Western Oregon, but some in Central. Our residential right now is about 60% spec construction. So we do a lot of new construction financing, but we love fix and flips. I love working on some of those smaller fix and flip projects, and we've done quite a few of those with this group. So that's been a really great venture for us. But also multifamily and commercial, we're pretty good at those. So if you have any unusual deals that you'd like to run by me, I'd be happy to talk through some numbers. I was really looking forward to that deal deep dive the other day, but that's what I do all day long, is analyze deals for people and see about getting them some quick financing. So if anybody has any questions, let me know. I'll drop my contact info in the chat.
So Zach, I'll share deal deep dive with you in April. How's that?
Sounds good.
That'll be awesome. All right, back to my share screen for one more screen or so. Yeah, whatever. That one, okay. And now, the moment we're waiting for, we welcome 2 local attorneys. However, one has left our meeting and is feeling ill. So I'm hoping the best for Peggy Richard with Hirschner Hunter, who suddenly was feeling ill today, couldn't continue on. But I'm very, very pleased to have Joel Smith with us from Schultz and Associates. I can't talk. And we are going to be talking about asset protection. Joel, tell us about yourself. I really don't know you that well, except for that you're a funny guy and fun to talk to. And you'll have to unmute yourself.
Yeah, there it is. Well, thanks, Grace. Thanks for having me. Thank you, Oria, for having me. I'm actually going to get right into the screen sharing as a little kind of about me slide coming up in a couple of slides. For those of you that were on hoping to hear more about the current landlord-tenant situation and kind of some of the debtor-creditor, landlord-tenant type stuff, that was going to be Peggy, so I'm sorry, but we're still going to try to have a little bit of fun. I set this for like half an hour, so I'm going to have to talk a lot slower. And we're still probably going to get out of here, I don't know, probably early. So hope you all don't mind. Try to save the questions for the end. Hopefully I'll get to it in the presentation, but if not, certainly let me know. And I only say that because once I start sharing the screen, I don't know if I'll be able to see you. So, all right. So with no further ado, all right. Everybody see that? Yeah. Okay. Good. I saw Grace mimic it, so I know that it's on. So let me start with full disclosure by saying that I am a trust-based estate planner, and while they are not for everyone, I believe that a well-drafted, well-integrated, trust-based plan can and often does eliminate or even solve some of the problems created by other estate planning tools. I announce this at the beginning so that you are aware of my inherent biases and you can adjust your interpretation of my presentation accordingly. I think that that's fair. All right, so that's, okay, good. So I am a California native who transplanted fully and wholeheartedly by the end of my first semester in law school. I graduated from Oregon Law, already passionate about estate planning, mostly because I saw how I could help other families avoid some of the tragedies that I had witnessed in my own family. My grandmother died without a will, and I watched her 5 daughters just go at each other's throats. Of course, she named one of them the executor, and all heck broke loose. And then a few years after that, I watched as she was taking care of my brother who had a terminal illness and had a power of attorney for her. But I don't know if y'all know this, when you die, a power of attorney expires with you. And so I watched her go through the rather grueling California probate practice or process. And it, you know, for 2.5, 3 years while she's mourning the death of her son, she's dealing with creditors and banks and property managers and all kinds of crazy stuff. And it didn't take long once I got up here and was apprenticing with an estate planner to realize that the right tools could have avoided both of those tragedies. Were completely avoidable. I built my own practice, Cascadia Estate Planning, with generous assistance from some individuals who are in the room right now. So you know who you are. Thank you. And then I joined the Schultz and Associates family back in March of 2020, just as COVID was kicking off. I traded in the discretionary time and self-direction for a salary, I think just in time. So as a trust-based planner, one of the main reasons that folks seek me out specifically is because they've heard that a trust allows them to avoid probate. And while that's true in most cases, it begs the question, why? Why do they want to avoid probate so bad? Why might you? So today we're going to explore this villain called probate just a little bit, and then and see if it's really as scary as some would have you believe. And then we'll take a look at you know, some various ways that it might be avoided. So what is probate? Well, it's a court supervised process basically for the transfer of assets and property from the deceased to the living, right? Basically, essentially, supervised, yeah, legalese for stuff. We got to get the stuff from the dead person to a live person. And this is necessary because, well, a dead guy or gal can't sign anything, right? So what do we do with anything that requires an owner's signature for transfer, like a car or a piece of property, bank accounts, anything titled in the dead person's name? We need someone to step in and be the personal representative on behalf of that person. And that's Oregon's name for an executor, right? Is a personal representative. So because the dead can't sign anything, they need a living representative. Oh, should hit the buttons. So I get asked this question a lot. If I have a will, do I still need probate? And the short answer is yes. Because a will has no legal voice until it's given a voice by the court. And in fact, the definition of probate is the official proving of a will, right? So in Oregon, which brings us to the question, kind of an important question, is whether or not a will is valid. In Oregon, a will is valid if it's made by a person who is 18 years of age, of sound mind. It has to be in writing. It has to be signed by the decedent and two, ideally, non-interested witnesses. So it's really important to make sure that all of Oregon's signing formalities are observed, but if they are, chances are the will's good. And so now in a will, you've told us what you want, and the legal process of getting the court to accept this as your testamentary will or your testamentary intent is called probate. But what if you don't have a will? Or what if the will was invalid? Or what if you've lost the will? Now, a lost will in Oregon is presumed to have been revoked by the person who wrote it. Or maybe you thought you told us what you wanted. I see this sometimes, right? You get like 15 typewritten single-spaced pages of everything that they want their helper or their executor or their personal representative to do for them. And they, you know, every little piece of lawn equipment, every little Hummel figurine, everything's got a home, and they signed it, but no one witnessed it, right? Or they executed it perfectly, but no one can find it, right? So now you have a problem. In each of these cases, you effectively have no will and you have died intestate, which means without a testament and or a set of instructions for us to follow. And that's okay. Button. Never fear. Oregon has a plan. So that reminds me, right? Because Scott knows I usually lead with this. Everybody in this room right now already has an estate plan. Do you know that? Every single one of you already has an estate plan. How do I know this? Because it's provided free of charge by the state of Oregon. So if you don't like that plan, stick with us. But never fear, Oregon has a plan. It's called the Intestacy Statute. And basically, it depends on how you're situated when you die. Married with no kids, kids and no spouse, you got a wife and kids, married with kids from a previous lover, spouse, whatever that may be, unmarried and no kids, or what if you don't have any parents? So depending on where you end up, Oregon's got a plan for you. If you're married with no kids, that's easy. The spouse gets it all. Kids and no spouse, the kids get it all, duh. Wife and kids, spouse gets it all. Married with kids from a previous relationship, the spouse gets half of the intestate property and the decedents inherit everything else. If you're not married and you have no kids, your parents get it all, right? It goes up and then it goes over and then down again. No parents either, your siblings will probably get it all. And finally, if there's no one there to get anything, well, then Oregon gets it, generally. So that brings us to probate avoidance, which is probably why most of you are here putting stuff into trust. Well, you just decided this was billed as asset protection, and we're getting there, I promise. And the first thing we need to look at when it comes to estate planning, I think if I asked everybody in the room what their definition of estate planning was, I think everybody would probably come up with something a little bit different. And so generally, the definition that I like to use is that when you're talking about estate planning, you really have to talk about three questions, which is the timing. Well, who gets my stuff? Who gets to play with my stuff, rather? Who gets to control my stuff, and when? When you're alive and well, you get to play with your stuff. You get to control your stuff. And when is when you're alive and well. And then if something starts to happen, if you lose capacity, well, then things start to change, right? How that changes depends on how you own or when you die, how that changes depends on how you own your assets. The principal ways that people own their assets I've seen on this call. I'm sure we have some people who own their assets all by themselves, free and clear, just them. I noticed there's a couple of couples. I'm going to guess and say that you probably own a lot of your assets joint or joint with right of survivorship, whether that's real property, bank accounts, even the way your cars are titled at the DMV. Another way that people, can do some kind of poor man's estate planning, right? It's fairly easy. It's relatively inexpensive and generally effective. There are some gotchas though, right? For example, when it comes to joint, you have to keep in mind that your joint owner's debts become your problem, right? You could accidentally disinherit family members. We see this a lot, where, you guys own everything together, then one of you dies, the other one goes on and gets married, and then somehow your kids end up not getting anything because the spouses and her kids maybe get everything. You also might have trouble selling or refinancing something if you own something joint. So usually that's when adults will, in order to get around probate, will just kind of add their kids to the deed. We see that a good bit, and that's problematic because again, when the time comes to try to sell that asset, if the person's not dead yet, for example, you still need their signature. And we'll come to incapacity in a minute. You got to watch out for unnecessary capital gains. When you transfer a property, even as a gift, if you put the kids on the deed, for example, and I think a lot of you guys are real estate investors, so you're probably already pretty savvy to this kind of stuff. But if you put somebody else on the deed, if it's a $300,000 house and you put somebody else on a deed that's joint, you just made a $150,000 gift to them, right? And so now there's a gift tax consequence. There may be a capital gains consequence. See your CPA because that's above my pay grade. But just kind of watch out for that stuff. And then finally, if your co-owner is incapacitated, you're going to need a court order in order to do anything with that property. The other big way that people own stuff is beneficiary designated, pay on death, transfer on death. In Oregon, we have what's called a transfer on death deed. So that simplifies things. Generally, you have to own the property outright, and there's a color of title for 18 months because the idea is to keep it within the family. But it is one way of transferring that property upon your death without a probate. The problem with POD and TOD, you probably already picked up on this, but they all require death, which means they all require, then again, you to die in order for them to take effect. Well, what happens if you're just incapacitated? Like I said, we're going to come back to incapacity in a minute. So what about what you guys are all here for? Oh, and then there's entity owned, and we're going to get into that right now. So what about a trust? Specifically, we're going to talk about a revocable living trust. And a revocable living trust, there are pros and cons, just like with anything, right? The advantages are that a revocable living trust avoids probate generally, especially if you own properties in more than one jurisdiction. I heard talk when we were talking about the haves and wants about people looking out of state for properties. And I think that's a great idea. But keep in mind, if you own property outside the state of Oregon, you're looking at more than one probate. And all of the attendant fund that goes along with that. Trusts are changeable, revocable. It allows the grantor to make changes to include the trustee, the person who's managing the trust, while they're alive. As long as you're alive, you can make changes to your trust. You can change who's controlling your stuff, whether it's you or someone else. You can add a co-trustee. There's all kinds of things that you can do to adjust that trust. What? Oh, so I thought there was a question there. Anyway, another big one is privacy preservation, right? It allows the transfer of assets to remain private within the bounds of the trust document itself, right? And there's a lot of ways that you can do that. The principal way is, again, and I hate to pick on probate, but it's an easy villain to pick on. When you go through the probate process, you have to understand that that is a public process. If you give me the name of somebody that's recently died and knows going through probate, we can get online right now and we can find out exactly what their inventory was, whether or not they owned that house, all that fun stuff, whether or not that Renoir in the living room was real or not. Your will becomes a public document. And so trusts allow for a modicum of privacy and also when titling things. So there are some tricks around there that we can discuss when we're face to face. Let's see. And then the next big one is minimizing estate tax. So in Oregon, at the federal level, you know that there's a $11.5 million exemption, right? And that's for all of those gifts throughout your life and for the size of your estate when you die. However, in Oregon, the size of that coupon is $1 million. So, and that's per person. So if you're a couple, you each have a coupon. And if you're using a revocable living trust at the death of the first spouse, we can split those assets and take advantage of both coupons. So that's one way that we can minimize estate taxation. And then also it's helpful for those of you that are coming from or bringing properties that are still characterized or monies that are still characterized as community property. We can better segregate assets within the trust. The disadvantages, they're not cheap to start. They're not cheap to get started. But again, I would say that that's mitigated by the fact that a cost of a probate is almost always going to be more expensive than a revocable living trust, at least the ones that we do, more often than not. The other big one is titling a property. You have to fund that trust. Once we create that trust, you have to fund that trust, which means getting assets into that trust. The whole idea really behind a trust is and the reason that they avoid probate and all that fun stuff is because we want to get as many assets in there as possible. So anybody have one of these when they were a kid? Yeah, okay. So I don't know about you, but for me, when I was a kid, I was going down to Tommy's house. I put all the toys I wanted to play with that day in the little red wagon, grab that handle and head on down to Tommy's house. If something happened to me, if I tripped or fell or whatever, I could let Tommy pick up the handle and keep running, right? Well, this is kind of a great example of a trust. We're going to get all our toys in here, our bank accounts, our houses, our rental properties, our LLCs. We're going to put them all in here. We want everything owned by or payable to the trust. And that way, if something happens to us, whether because of incapacity or death, and that handle hits the ground, our successor trustee just picks up the handle and keeps running, right? So, but in order to get stuff in there, you have to retitle those assets. And so, there's a little bit of work that has to be done. That's called funding. And then maybe the biggest problem with the trust is that asset protection is relatively limited, especially for the grantors, for the people that set up the trust. There may be asset protection down the line for your heirs. We can get to that in a little bit, but it's relatively limited at this level. And so I can already kind of hear it, kind of the elephant in the room. I'm sure by now some of you are already asking, well, what about an LLC? And so there's no doubt that an LLC is probably the preeminent way to own investment property. It does have some drawbacks. They can be expensive to set up, especially if you want all the bells and whistles. There's an annual renewal fee and a not insignificant amount of filing that needs to take place that is required by state law. But generally, these things are outweighed by the asset protection that LLCs afford. So if someone sues me and I've got stuff in an LLC, what can they get? Well, so without limited liability, your business creditors can reach both your business assets and your personal assets. And the reverse is also true. Without limited liability, your personal creditors can reach both your personal assets and your business assets. But with limited liability, your business creditors can only reach business assets. Your personal creditors can only reach personal assets. And the best way to think about that is kind of like you're going to put that asset, think of that asset as being in a bubble, right? And you can only get to what's in that bubble. So if you're attacking from the outside, it's really hard to get in and get what's in that bubble. If you're on the inside, and this is why some people have an LLC for each property, because if you're on the inside, whether that's a slip and fall, lead paint, any number of things, right? Now, granted, and we can talk to Jeanette about this in a second, but insurance is going to cover a lot of those things, right? But there are some things that insurance doesn't cover. Most policies, and again, you can ask Janet about this stuff, and she can guide you through this, but most policies have exceptions for lead paint, for mold, for illegal activities, right? And so what if, unbeknownst to you, somebody's set up a meth lab in one of your apartments and it blows up? Well, that was an illegal activity. Or maybe it doesn't blow up. Maybe you never catch them doing it and they move out. But another family moves in, they've got little kids, and several months later, those kids end up at the emergency room. They do a tox screen and they find out, oh, there's some crazy stuff going on in there. If they test that apartment, maybe the carpet, maybe the paint, whatever it is, and they find out there's some of that nasty chemicals from the meth lab that have leached into that stuff, you're going to be liable. Anyways, I'm not trying to paint a scary picture. Well, I am, but the point is that happened inside the bubble. And so the creditors can attack whatever's inside that bubble. If they're suing from inside the bubble, they can get whatever's in that bubble, which is why, like I said, some folks will wrap an LLC around each property so that they only get what's within that bubble. Let's see. So basically, so far we've looked at 4 ways to own property. Well, we're about to talk about them. In your own name, which if you own stuff in your own name, I guess obviously the downside of that is that there's you don't have to worry about all that, renewing your LLC stuff every year, and you don't have to worry about all the filing stuff, but you also have no protection. In a revocable living trust, similarly, you don't have to worry about renewing stuff, and pretty much once you set it up, it stays the way it is unless you want to change it. So it's really flexible. That's great. But again, not a lot of asset protection. In a single member LLC, you have to kind of be careful there. A single member LLC is just you, which means it's pretty easy to point to the person responsible for the control of that operation. And if I come after you, if I win the lawsuit and I get a charging order, I stand in the shoes of the person that I sued. If it's a single member LLC, I now have access to everything in that LLC. If it's a multiple member LLC, and especially if it's a multiple member manager managed LLC, I only stand in the shoes of the member that I sue, right? And that sucks if you're the judgment creditor, and here's why. If I sue you and I'm successful, I stand now in the shoes of you as a member of that LLC. But that's all I can do is stand in the shoes. And if I'm not one of the managers, I have no vote. And what happens is, and this is why it's not a great place for a judgment creditor to be. What happens is the managers may decide not to make any distributions of income, but that LLC is still generating income. And at the end of the year, at the end of the tax year, the allocation still has to go out in K1s. So I'm about to get taxed on money I'm not even getting. It sucks to be a judgment creditor when you're standing in the shoes of a member of an LLC. Which is why nobody wants to do it, which is why nobody wants to sue an LLC, right? So what all of this what we skipped over a couple of times now, we've been exploring what happens when you die and what happens to your assets, right? If you own them in your own name, you better have a will. If you have a will, at least you can say where the stuff's going. But in all of those cases, there's going to be probate, right? However, and if you have a revocable living trust, handle hits the ground, your trustee keeps going, that's great, right? LLC, well, we're going to get into it in a second. Let me let the slideshow do the talking for me. So if you own stuff in your own name, you better have a really good power of attorney. Really well drafted, comprehensive power of attorney that was signed, executed sometime in the last couple of years. Here's the thing with powers of attorney. Banks don't have to take them. Financial institutions don't have to take them. And if you think about it from the financial institution's perspective, it makes sense, right? If I walk into a bank and I present a power of attorney for Scott's account, say, right? And I say, hey, I'm Scott's power of attorney, and he's lost his marbles, and I'm going to need some money out of his account to pay for his memory care. And they give me the money. And then the next day, Scott walks into that bank and says, you gave my money to who? They're on the hook, right? And so you can appreciate that financial institutions are kind of wary of powers of attorney. And the two powers of attorney they're the most wary of are the ones that were signed, say, 10 years ago, because they don't know if they're still good, and the one that was signed just yesterday, right? In any event, you present that power of attorney, by the way, it also has to go through their legal department, get vetted, and maybe come back to you in a week or so. I just went through this with my mom. I put my mom in care. I had a power of attorney for her, and I had to wait as that power of attorney went through the legal department of 2 or 3 different credit unions that she had accounts at. So not the best tool, right? Those are backwards. What if it's in an LLC? Well, you better have a really well-drafted operating agreement. Some operating agreements, again, this is where it comes down to having an LLC that has all the bells and whistles. Some operating agreements will include, most will include some at least basic attempts at succession planning, but only the best drafted ones have really thorough succession planning provisions. And even those don't generally, are generally for death. A lot of times those don't cover incapacity planning. Revocable living trust, you can probably see where this is going. That allows you to control over who succeeds you, who gets to pick up that handle and keep running, what they can do when they pick up that handle, because attached to that handle is a book of instructions. That's the trust that says, here's what you can do and here's what you cannot do, and under what circumstances. Now, our trusts include something called a private determination. In other words, instead of having to go to a court of law and have you adjudicated as having lost your marbles, we're going to pick you're going to pick a disability panel, a group of people that decide whether or not you're crazy. And if they do, then you get replaced. And so you get to determine under what circumstances you're incapacitated. So the best of both worlds is a combination of a revocable living trust as a member of a multi-member manager-managed LLC, because this allows probate avoidance, estate tax mitigation, incapacity planning, and asset protection. And so that's pretty much it in a nutshell. There's a bunch of stuff, more stuff that we can handle, that we can cover if you want, but I'm going to move into questions here in a second. I would encourage you to write down my information. It's on the screen there, my phone number, my email address, or you can come in and visit us. We are open for business, masks and wiping down services and all the fun stuff right down here at Will Gillespie Road. And I will say this, it's down at the end. If you call and so here's the thing, give us a call and sit down with us and talk about what your case might look like. Every case is going to be different. And if you call today, not today, nobody else is here, but if you call tomorrow and make an appointment, if you mention this seminar, you can get $500 off any trust-based estate plan, even if, and that includes plans that we would do that might include an LLC, because we also do that. So at this point, I'll stop the share and we can open it up for questions.
Thank you very. Yeah, I just want to say thank you very much, Joel. I have questions, but I'll let other people go first. And if they're shy, then I'll go for it.
Joel, on your very last point, where you have the combined revocable living trust, but as a member of a multi-member LLC.
Yes, sir.
In that situation, let's say for a couple that is doing their estate planning, just 2 members, or where do they get the other members? What's a typical combination of members?
So if you have a couple, then you naturally have a multi-member LLC. In Oregon, because it's not a community property state, you can't have a couple as a single member LLC. You can do it in California and you can do it in Washington because they're community property states, right? But in Oregon, because we're a separate property state, a husband and wife can't be a single member LLC, right? So you pretty much have to do a multi-member LLC. The reason you want it manager managed is because you want the members and the managers to be succinct entities. Now you can be both, but you want the members and the managers to be distinct entities, right? And as to answer your question, but let's say that you're a single guy or gal, right? And you want to take advantage of this. And so what we would do is we would do what's called an irrevocable management trust. And you take 99% of that LLC, or you put 99% of that LLC in your revocable trust, and 1% of it in an irrevocable management trust. And now you have both members and you control both members.
Okay, let's just ask a stupid question here. What's the difference between irrevocable trust and living trust and a revocable living trust?
So there's really not an irrevocable living trust. So trusts got popular in the 80s for tax purposes, right? And at the time, irrevocable trusts were all the rage. It was a way to get money out of my personal control and show the IRS, hey, look, I don't have that money anymore. It's been put somewhere else. Probably the biggest one, and the one that's still with us, is the irrevocable life insurance trust, whereby if I buy insurance for myself and put it in an irrevocable trust, as long as I survive for 2 years after I do that, that asset, that $100,000 or $500,000 worth of insurance that I bought is no longer a part of my estate. This was huge when the estate tax exemption was only $600,000, and even when it was only $1 million, right? But now with the estate tax exemption at $11.4 million, and granted, that's going to change. I really expect that is probably going to change for one of 3 reasons. A, if Congress does nothing, and Congress is really good at doing nothing, that's going to sunset in 2025, right? And so it will revert back to $5 million adjusted for inflation. So it'll probably be around $6 million. The next thing that could change is is sooner rather than later. I'd say probably now we're down to 2 reasons, because now we have a new administration. And probably the next thing that's going to change is all of this spending that we're doing is going to have to be paid for at some point. And the Fed printing money is not always going to be the answer. And so generally, the left tends to prefer smaller estate tax thresholds, generally, sometimes as low as $3.5 million. I don't think they'll get that through the Senate, but it's probably going to shrink a little bit. And I think that's going to be attractive to both sides of the aisle at some point, because at $11.5 million, $22 million, $23 million for a couple, there are fewer than 1,400 families in the country that are in that bracket. So it's really hard to defend at some point. So that might be shrinking. Point is, the tax thing has become less of an issue. Now in Oregon, like I said in the presentation, that coupon is still only worth $1 million. There's been some talk about parity, but I don't see it happening in this next session. It's still important to do tax planning for those purposes. To your question though, Grace, revocable trust came along because we wanted to have the flexibility to make those changes. We wanted something that was similar to a will, but had more flexibility. And what's nice about a trust is really just a contract, right? It's a contract between 3 parties. The grantor, or the trust maker who creates the trust, the trustee who controls the trust, and then the beneficiary on whose behalf the trust is created. And when you create a revocable living trust, you get to be all 3. You get to wear all 3 hats. And if you're single, you wear all 3 hats your whole life. If you're married, you wear all 3 hats until the second of you dies, right? So as long as one of you is alive, you can make changes to that trust. So that's what makes a trust revocable. And here's one more wrinkle. They're called revocable grantor trusts, meaning I use my own social security number to identify my trust, right? It's basically a pass-through or a non-existent entity as far as the IRS is concerned. Any income that trust makes goes on my personal 1040, right? So it uses my tax ID as the tax ID for the trust. When it becomes irrevocable, it becomes a administrative trust. We're going to have to get it its own tax ID because, again, like before, the dead guy can't have his own social security number, and so it needs to have its own identification. But one more little wrinkle. In the Medicaid planning arena, there are irrevocable pure grantor trusts. This is a relatively new concoction that uses the grantor trust rules so that I can be the trustee of my own trust, even if I get money out of my control for Medicaid purposes. And anything that gets transferred into that irrevocable trust is no longer a available asset for Medicaid purposes, but that's a very specialized trust and not cheap.
Thank you.
Grace, thank you for asking awesome questions all the time.
You're on mute, Grace.
Yeah, thanks, Shalene. But so what I understood out of that was that it becomes an irrevocable trust after the subject dies. I don't know how to put it.
After the surviving spouse dies.
Yeah. Okay. So if it was just me, it would be after I die. If there's 2 of us, it would be after both of us.
Well, and even that is a little nuanced. So the way that we achieve the tax planning that I talked about is, let's say that you have a couple, let's say the Glasses, right? Oh no, that's mother and son. Grace, you said you're married?
Yes.
Okay, so and you and your husband, I'm guessing, own most things jointly?
So for our rentals, we have them in an LLC that we're the 2 members of.
Okay.
Yeah.
But other stuff like your private home and your bank account, all that other stuff, right? So let's just talk about that stuff and not your business assets for right now, right? So you and your husband own everything jointly. Let's say that all put together, your estate is worth $1.5 million, right? When he dies, and I'm sorry, guys, statistically, we go first. When he dies, you are now going to inherit all of that. You're now going to be worth $1.5 million, which is great. But if you die in the next couple of months, now you have a $500,000 tax exposure.
To my heirs.
No, your estate.
My estate, yeah.
Your estate, right? You get a coupon for the first $1 million, but now you're looking at a $500,000 at between 10 and 16%. It's not huge. It's not as bad as the 40% tax hit at the federal level, but it's still $50,000 that your heirs shouldn't have to spend. Instead, if you had that in a revocable living trust, when he died, we would split those assets. We'd fill up his bucket with $1 million worth of assets and use his full coupon. And now you have a $500,000 with $500,000 of the headroom.
Okay. That
makes sense?
Yeah, that makes sense. Yeah. Okay, let's see. You said the word stand in the shoes of the manager of the LLC in a lawsuit. What
The
does
member.
that mean?
The member of the LLC.
In the member of the LLC. Okay.
Yeah. So you and your husband, here's a great example. You and your husband are members of an LLC, right? And you drive into the front of my office, right? And your insurance doesn't cover the whole thing, and I come after you, right? If I'm successful in attacking your business, all I would get if I attacked you would be your portion of, I would stand in the shoes of you as the member of that LLC, right? But of course, you and your husband are savvy to that. And so you take one look at that and you say, that's fine. We're just not going to make any distributions of the rental income that we're creating. But come tax time, we are going to be sending out K-1s that are going to allocate to you, standing in the shoes of the member, the tax exposure for that year. So he's going to be paying taxes. I'm going to be paying taxes on money I didn't earn.
Gotcha.
So you can appreciate how nobody really wants to do that, right? It's not a great place to be.
I got questions if you guys don't, because this was really new to me. I have to say, I've not studied this at all. And I thought what I would be getting out of this was to put my fourplex, my rentals into a trust. They're already in a two-member LLC.
But is it member managed or manager managed?
Well, I managed it, so I don't know what that means. Member managed.
Well, so you can separate out the office of the manager, right? So that you might be both, but again, when I get sued, I want to be sued as the member, not as the manager, because manager has control decisions that they can make and usually gets to vote as well, right? The other thing is being manager managed. Dan, thank you, Dan. Not that I'm surprised. You guys have your stuff pretty tight down. So, and again, so something that Dan's partner actually and I were talking about not yesterday, but the day before, I think, was that, and we talked a little bit about the privacy, for example, that a trust affords. And so if I own my property in an LLC that's owned by a trust, okay, there's a couple different ways to look at this. My LLC is going to be registered with the state of Oregon, right? Because it has to be, although I can get an LLC in another state as well, right? But my LLC is registered with the state of Oregon, but my responsible party is an attorney in Utah. You think when you call that attorney in Utah, he's going to give you any information about who owns this LLC?
No.
No, right? And then another fun trick that Ed and I talked about is when you title something in the name of the trust. When I title something in the name of my trust, let's say that I put this building in the name of my trust. when I first do that, my mother-in-law is the trustee of the trust. As soon as that deed is recorded, she's going to resign and the successor trustee is going to step up. That's a private document. Nobody gets to see who the successor trustee is. And as far as anybody doing an asset search is concerned, they're not going to find my name, even though I now control the outcome of that property. So you get to have privacy, you get to have control. And then when you combine those things, when you combine the privacy and control of a revocable living and the probate avoidance and the tax mitigation of a revocable living trust with the asset protection of an LLC, I think now you have a pretty magic combination.
Joel, I have a question for you.
Yes, Grady.
So when you transfer property into this level of asset protection, you want to be done doing any kind of cash out refis? Are there issues with trying to do financing later on?
There are. Most mortgage houses won't deal with a property if it's owned by a trust. Really, they don't like it to be owned by any entity but a human being, because it's a lot easier to go after a human being, right? But none of the mortgage houses that I know will touch a refi if it's owned by the trust. So usually we have to deed it out of the trust, have our clients do the refi, and then deed it back into the trust.
Okay, so that is possible.
But that is possible, yeah, because it's just recording a deed, and that's pretty simple, right?
We do deal with trusts, but at the same time, we require personal guarantees and corporate guarantees and get every involved person and entity to guarantee. So.
Okay, there you go. Thanks, Zach.
Okay, so I have a question. I've known people that have had non-revocable trusts, and then when somebody dies and it's all locked up because the owner of the trust, not say he didn't die, but the beneficiary of the trust died, and then he can't control any of it. What happens then? I mean, I know that I had a friend, and his wife passed away. She was executor of the estate. Somebody else became the executor of the estate. He tried everything to get it to become a revocable, but they couldn't do it even through the courts. Attorneys couldn't make it work.
Right. So because when the grantor dies, when the person who creates the trust dies, so if you're a couple, that's one thing. But if what that tells me is that they may have had separate trusts, when the grantor dies, that trust becomes irrevocable.
Well, but he didn't die.
But you said his wife died?
His wife died.
His wife died and she was the trustee?
Yes.
So if she had created the trust herself and she was the trustee and didn't leave him as successor trustee and didn't have a trust protector, which is another feature that the let's just say the better trusts have, I know ours do, it doesn't have a trust protector that can make those modifications post-mortem, then you're dealing with an irrevocable trust, unfortunately.
But this guy, it was in his name, and it said his name, irrevocable trust. But he bought and sold a lot of real estate through it, did everything that he possibly could to keep from paying taxes on it.
Yeah.
But then in the end, since it's non-revocable, he could not control it. And it actually went to a secondary beneficiary, and they stole all the money. It was only $60 million, so it's what he lost. And every attorney in Oregon couldn't save him. So
yeah,
there was
I'd be really curious. That Brad, if you can get a copy of that, I'd really love to see that trust, because that's a really interesting fact pattern.
I don't know that I have a copy of it, but I did a lot of real estate with him, and so then of course escrow had copies of it, but I don't know, it's just late in the game now. He's passed just recently.
Well, and chances are there aren't too many people that actually have a copy of that, because again, that's another thing that's great about a trust, right? Is that it's such a private document. And Zach can I don't know how much you guys require when you do the deal, when you're dealing with a trust, but for most things, when our clients and their financial institutions come to us and say, well, we need to see a copy of the trust, most of them don't even try because they know what they're going to get. They're going to get a certificate of trust that shows them that the trust is in existence, that it's revocable, who the currently acting trustee is, and maybe they might get a few pages from the trust, excerpts from the trust that show that it's created, who the current trustee is, who the successor trustee is, and what the powers of the trustee are. That's all they're entitled to. The rest is all private document. So, so that's one of the things that's nice about a trust. It rarely, if ever, becomes a public document.
Well, I know he got chased by the IRS for not paying taxes out of it, but all the money went into the trust and he didn't have to pay capital gains and things like this. He just kept his money flowing. All the business was done, real estate wise, it was all done in the trust. And, you know, the IRS came to me and he still didn't have to pay. I mean, he hadn't done anything wrong. Whoever had his attorney set it up, set it up good, except it was a non-revocable trust.
Well, like I said, I would love to see that and how that attorney did it, because I'm always down to learn something new, right? Trusts do get taxed. Like I said, a revocable living trust gets taxed by the grantor's Social Security number. An irrevocable trust has its own tax ID number. And something to keep in mind, by the way, when we're having this discussion about trusts is once that trust becomes irrevocable and has its own tax ID number, you really now want to take a look at whether it's worth keeping those assets in the trust, especially if they're income producing assets, because trusts pay taxes at a 39.5% tax rate. It's a really high tax rate for income. That's recent and that might change, but as of now, it's really expensive to operate income properties through a trust unless you really need to have some of the other features of a trust that we talked about. So, but that's after the transfers have already happened. And at that point, you can title it back out of the trust, leave it just in the LLC. The transfer has already been accomplished. I think at that point, it's cheaper to just have whoever inherits the trust or the property at that point do their own estate planning, put it in their own trust. Now it's a revocable living trust that's not paying at that tax rate.
Do you have to have all of your property in a trust? Can you have some in a trust and some not in a trust?
Yeah, you can do whatever you want. Just keep in mind that any property you don't have in that trust, you're going to be probating.
Oh, okay, that's the difference. All right.
Yeah.
Okay.
Yeah. And again, I don't know if y'all caught it, but those of you that are looking at, buying property in another state, right? You need to probate property in every state, in every jurisdiction in which you own property, right? So in Oregon, fortunately, we have statewide jurisdictional control. As I understand it, there are some states where it gets down to the county. And I don't know that for a fact. I haven't seen one. But we do have clients right now that I'm doing probates for that have assets in Oregon, California, Utah, and Wyoming. That's going to be an expensive probate. They really should have done a trust.
Because they have to pay every attorney in every state.
That's correct. We are
and all the fees.
Associating. We have local counsel in each of those states that we're associating with. Wyoming, we're fortunate because it's just an oil and gas lease in Wyoming. Because so many people have oil and gas leases in Wyoming, there's a statutory provision in the Wyoming statutes that says that they will recognize a probate in a foreign jurisdiction as controlling, which means we're just going to use our Oregon probate, but we're still retaining local counsel because I don't fully understand those rules. I'm not licensed in any other state currently. So I want attorneys that are licensed in those states to be prosecuting those probates.
So rather than me asking all my questions that I had pop up in my mind during the presentation, is there something, a source, a resource you can point me to read up on before I come in for my husband and I come in for an appointment with you to help me understand what the heck you're talking about?
I tell you what, there is a ton of information online. If you put in revocable living trust, you'll get a ton of information. You have to be a adroit consumer of information, though. Just because somebody's trying to sell you something doesn't mean the information isn't good. For example, there's some great information on the LegalZoom website, right? There's some really good information on the NOLO website. And then there's one of the larger estate plan, national networks of estate planners is called Wealth Council. And they own the website estateplanning.com. And there is some great information on the estateplanning.com website. But your best bet really is to just come in and talk to us. You know, the first hour is free. Well, I should say at no additional charge. It doesn't cost anything to come in and sit down with me and take a look at what you're sitting on and what's going to be best for you. And I'll be honest with you, if a trust doesn't fit your fact pattern, not everybody's does. You know, when we looked at that that intestate succession thing, right? If you want your stuff just to go to your spouse, that's what happens in an intestate probate. You don't even need a will, right? So if the Oregon plan is okay for you, and it is for some people, that's all you need. And like I said, you know, I'll pull my own covers, right? Full transparency. So we do trusts all day long for $37.50 for a single person, $47.50 for a couple. And again, if you mention this seminar, I'll tell you what, if you mention this seminar, I'll give you $500 off when you call us in, right? For a bonus, I'll throw in a See's Candy gift certificate if you can name the movie that I was having fun with all through that presentation. In any case, but you got to ask for the gift certificate. Point being, we do that because we used to have seminars. We used to do a lot of our business through seminars, in 2-hour seminars. People give us 2 hours of their time, and we would go through a lot more stuff though, right? And in a lot more depth. Now we just do that stuff one-on-one, and we can do that because when we know exactly what we're talking about in advance of your appointment with us, we're going to send you a packet for you to fill out that's going to give us a lot of information about what you're sitting on. And we need you to be honest because we need to be able to give you the best possible, you know, legal counsel. But like I said, if it doesn't make sense for you to do a trust, then we'll tell you. I'm guessing for most people on this call, a trust is going to make a lot of sense, but there's no guarantee.
So I got out of the, towards the end of the presentation, I thought you were saying, so if I have property, investment property in an LLC, then I put the LLC in the trust. Is that right?
Other way around, kind of.
Okay.
Well,
okay, thank you.
Yeah, so the trust is going to be a member of the LLC. Now, that's one way. The trust is the trust is going to be a member of the LLC, but basically that is putting the LLC in the trust, right? Because so there's a couple different ways to do that. If, for example, you're in an LLC with a bunch of different people, right? You can always assign your shares of that LLC to the trust,
right?
Because the point again is to have everything owned by or payable to that trust, right? And the reason I say payable to, just so we're clear on this, is that a trust isn't going to own outright every asset. Some assets we generally don't put in trusts. So qualified assets, right? Like an IRA or a 401k, we don't put them directly into the trust, but we make them payable to the trust. We want the trust to be the beneficiary so that it flows through that trust and the trustee has control of that money when it starts being sent out. Thanks, Stacy. You're awesome.
Okay, who else has questions?
Joel, I have a question. On your charge to do the work, does that include titling everything, doing new deeds and setting everything up?
So we assist you with the funding. We'll do the deeds. You'll have to pay for the recording. We'll send it in and make sure it gets back to you. And then with regard to bank accounts and your brokerage accounts, your insurance, what have you, we're going to send you home with, we'll either send you home with letters and you can take them to the bank yourself, or we'll mail letters out on your behalf, basically asking them how we want them retitled. So that's the funding piece. We have a dedicated funding coordinator. That's all she does all day long. She's amazing. And I should say too, that for that price, it's not just the trust. So a trust package also includes a will. As much as I badmouth kind of wills tonight, we include a will in the package. It's called a pour over will. It's a very specific kind of will, POUR, pour over will. And what that does is it takes any assets that we miss or that aren't owned by the trust and pours them into the trust at your death. It's rare that we need to use it, but we want it there just in case. For example, let's say that after you die, we find, I don't know, $50,000 worth of savings bonds with your signature on them in your sock drawer. Well, we didn't know, right? So we're going to use that pour over will to pour that stuff into your trust. So it's going to become with a pour over will, powers of attorney for your key helpers, for your trustee and successor trustees, and then an advance directive. And we'll walk you through that process as well, so that you're covered, not just at death, but again, so important. I can't stress this enough. Incapacity planning is so important. Everybody, almost everybody on this call at this point, right? There used to be, I would say that 60%, then it was 70%, then it was 80%. Most of us at this point are going to, because people are living longer, but they're slipping sooner. And so most of us at this point are going to spend some time with other people making decisions for us. And what happens to your stuff when that happens? More often than not now, we're seeing that that's the bad thing that's happening with our clients. And so their successor trustees have to step up, right? But at least they've made those provisions. They know who's going to be taking over when they can't anymore.
So Joel, you alluded earlier to potentially putting each property in I think it was in a trust, which then becomes a member of the.
No, so what I was talking about was putting each property in an LLC, right? So again, if you think of each LLC as a bubble, and if the LLC gets sued from the so there's two ways of attack, from the outside and from the inside, right? So from the inside, if you have a rental property, for example, and again, slip and fall, probably going to be covered by your insurance, but if something catastrophic happens to that property and other people are affected and they sue you, they can get whatever's inside that property. If you're holding 3 properties inside that property or inside that LLC, and that happened in property A, they're going to sue you for property B and C. Does that make sense? Whereas if you have property A in an LLC and property B in an LLC and property C in an LLC, they're only getting what's in property A or in LLC A. Does that make sense?
Yeah, got it.
Yeah.
So I have a question.
Yes.
How about subchapter S's? I have my stuff in subchapter S rather than LLC.
Right. So a subchapter S isn't a bad idea. And an LLC, by the way, you can elect to have an LLC be a subchapter, be a sub S corporation, right? So your LLC, an LLC can be a subchapter S. The trick there being, unless the trust is specifically authored or drafted to include subchapter S, be able to hold subchapter S shares, a lot of trusts don't. And you get into some of those little wrinkles, but it's not a bad way to hold property.
Well, I originally had it for business, and I had it back in the 80s. And at that time, LLCs didn't have the protection. I mean, that's back in the days of LLPs also. And
yeah,
it just did not have the protection that a subchapter S did.
Yeah. Yeah. Anymore though, unless, the thing is if you're not, if you don't want to deal with, self-employment tax and all that other stuff, I don't know why you'd want to. I don't know. There's a little bit of extra complication or complexity, I think, with a subchapter S that if we're just trying to get the asset protection, I would argue is potentially unnecessary, but it's not a bad thing.
I did it originally for liability protection for
yeah.
that I owned.
Yeah, like you said, back in the day, that was the best way to get it, right?
Yeah.
That's really a question I would ask, your bookkeeper or CPA about if you decide to maybe make that election. definitely talk to your CPA or your bookkeeper, your tax professional about that and what the tax ramifications of that are. And at the end of the year, are you going to have to do a self-employment tax? How are you going to be reporting your income? How are you going to be making those distributions? And what tax effect is that going to have versus an LLC?
Yeah, and I do know that I pay self-employment tax because of it.
Yeah.
We have our LLCs in a different state, but when I went to go open a bank account, I just wanted to make this comment for everybody. If you're going to open a bank account, but you have your LLC in another state, make sure you file a foreign entity. I forget what
yeah.
I learned the hard way and had to go to the bank twice.
Yeah. With the state of Oregon, right? Because if you're going to be doing business in the state of Oregon, they still want their pound of flesh, right? They still want their pound of flesh. But yeah, Dan's right. Out of state or foreign LLCs, great tool, but there's still a pay to play, right?
Pay to play.
And keep in mind too, that even if you have a foreign LLC, if you're doing business in the state of Oregon, not only do you have to keep track of that, but if you're doing business in the state of Oregon, you have what are called sufficient contacts to be brought under the jurisdiction of an Oregon court. So just because you have a foreign LLC doesn't mean you can't be sued right here. Anybody else?
I don't know if there's a quick answer to this, but the difference between a member managed and a manager managed.
Well, so a member managed is just lacking one kind of extra layer. If I'm in a member managed LLC, it's managed just by the members. If I'm in a manager managed LLC, the manager could be one of the members or it could be an outside party, right? And your operating agreement is going to make that determination, is going to make that stipulation, whether it's member managed or manager managed. And it's just something that the Secretary of State needs to know who's running this thing, right? And how professionally are we running it? But if you have a manager managed LLC, you have that extra little layer of it wasn't me.
Okay.
My CPA told us to make one of us so that the IRS doesn't elect one of you automatically. Just
yeah. Yeah. And it's just a modicum of control, right? And again, if you see problems coming down the horizon, you can always offload the management of the manager managed LLC to another entity. But if you register as a member managed LLC, you foreclose yourself from that. One of the members has to be kind of, well, that's the other thing too, is okay, here's a big difference between a member managed and a manager managed LLC. If it's a member managed LLC and I sue you and I step into the shoes of you as a member, the members do the managing, which means I now have a vote, right?
Okay.
If it's manager managed and you're just a member and I step into your shoes, I don't have a vote. I don't get to determine when I get an allocation or when I get a distribution, right? So just think of who's going to be stepping into whose shoes and when.
Are there multiple managers in a manager managed?
I mean, there can be. It just depends on what the operating agreement is set up to do.
Okay.
Right. So for all of these entities, right, there's going to be a document that's going to lay out, just like the trust document itself is just a contract that says, here's how each of these things works, right? Ours are set up, for example, to be kind of through a time span, right? And so when you're alive and well, when you're incapacitated, death of the first spouse, death of the second spouse, and then what happens to everything else, right? And so it kind of tells a story as you go through our table of contents, as you go through the trust, it tells a story. A well-drafted operating agreement is going to be kind of similar, right? Here's what we're going to do in good times. Here's what we're going to do in not so good times. Here's what we're going to do when the poop hits the fan, right? So.
Thank you.
Guys, follow his advice and have trusts, as a member of an LLC and you guys are coming in for a loan, just be ready for a lot of documentation.
Joel, can I ask I do have a trust. It's a personal, but I set it up like 12 years ago.
Mhm.
It's worth coming in and reviewing all this stuff with you because I'm also from Southern California and I moved up here 6 years ago. So things are a little different.
Yeah, absolutely. Absolutely. And like I said, so here's the thing. So it's a little dated now. I think it was 2017. Wazoo, Washington State University did a survey, and they found that out of 100 estate plans, 4 of them worked. And what I mean by worked is they did what the people thought they were going to do. Well, my estate plan does this, and people got exactly what they expected out of them. Only 4 in 100, right? Most of that was because of the long span, and you kind of alluded to it, the long span between reviews, the long span between updates, right? The average life, the average amount of time between updates was something like 14 years. So you're right on track at 12.
12 years,
right?
yeah.
So if you come in and you tell me, here's what I want my estate plan to do, we'll look at your estate plan and see if that's exactly what it's going to do. And if not, we'll tell you what you need to do to get it up to where you need it to do. I will say this, I don't make amendments to trusts I didn't write, right? And there's a reason for that, right? And so if I didn't write the trust, I'm going to do what's called a restatement, which is basically I'm going to gut that trust and put my trust in its place, right? And the reason for that is that if I make an amendment to a trust, I have now adopted that work as my own, and I'm not adopting some other attorney's work as my own.
Yeah, it's not complicated.
Right. But a restatement is kind of like, and I love talking to real estate investors because y'all would get this, right? You find a nice piece of land with a tear down on it. All you really want is that address, right? And so a restatement basically does that, right? We're going to use the name of your trust because you've already done all that funding. We've already put all of our stuff in our little red wagon, right? We're going to use the name of that trust, but we're going to gut the inside and we're going to put our modern trust on the inside. And so basically a restatement is usually what we're going to end up doing. And at that point, it's the same, basically the same cost. Yeah. And then, but the reason I mentioned the costs, I totally got away from this. The reason I mentioned those costs, and not only to be fully transparent, but to let you know that, so since I got here in March, Scott has put me in charge of the probate practice. And so I do a lot of probates now, probably 60 or 70% of my practice now is probates. I love doing trusts because there's always different new things, but I've been doing a lot of probates lately. And I can tell you that our probates generally run between 2 and 4% of the value of the estate. The gross value of the estate is what it costs to put something through probate, versus less than 1% for a trust that's regularly updated. And we know exactly what we want to do with that. And so there's still some post-administration cost for a trust, but it's nowhere near like a probate. And I will tell you that a probate is running somewhere between $5,000 and $7,000 for a relatively simple probate. So, yeah, it just depends on really when you're looking at like wills versus trust, probate versus trust, you're really looking at, when do you want to spend the time? Somebody's going to spend the time, somebody's going to spend the money, somebody's going to expend the energy to do all this stuff, right? And you can either do it for your heirs, or you can cross your fingers and hope that they do it right when you're gone. And it's interesting to me that, I don't know if anybody on here like has kids, right? Usually the folks that I talk to that have kids get this one. Most people will spend more time giving instructions to a new babysitter than they will leaving instructions for what happens to them when they die. Right? The first time you're going on a date with a new babysitter and you tell her, here's where this is and here's where that is and here's who you call, and you have a list of instructions this long, and you're making sure everything is exactly the way it's supposed to be. That conversation for most people, unfortunately, is longer than the conversation they have with whoever it's supposed to be that's taking care of their stuff after they're gone. So, it's fun.
Okay. I might be calling you tomorrow.
Very cool.
Well,
for those that didn't have their pens and pencils ready, Grace, are you going to send out our contact info?
No, I've got you all for myself. Hello.
There's enough of me to go around, I promise.
So let me see, you put it up on there, but I will send it out in an email along with the link to the video if you want to rewatch this. There was a lot, a lot in there. So for everyone, and it will be in there for other people that were not able to make it tonight as well. So I thank you, Joel. It was a lot. Thank you. And
We ended up going the whole time. I'm surprised.
yeah, you did. I'm glad I'm glad I personally separated the two conversations. We'll hear about, we'll reschedule the evictions and that kind of stuff, the Oregon laws that are going on with renters and squatters and that kind of stuff for a later date. I'm sorry that Peggy couldn't be here tonight. She was here, but she couldn't make it the rest of the way, and I hope she's doing okay. Thank you, Joel, so much. Your energy was enough for all of us. Hello.
Thank you to everybody who's thanking me in the comments. I truly appreciate it. It's been my pleasure.
Thank you. And good night. So we wave, clap.
Good night.
Thanks, everyone.
Bye-bye.
Good night, everyone.
Bye-bye.
Bye.